We are Legally Sis. Welcome to our podcast.
The information provided in the show is for general informational purposes only and should not be construed as legal advice on any subject matter. No attorney-client relationship is created between you and Duran Law.
Hi, welcome to Legally Sis. I'm Attorney Wen.
And I'm Attorney March. Welcome to our podcast.
How are you?
I'm good. Thank you for asking.
Okay. I think for this podcast, we're going to discuss about title transfers.
Yes, and also due diligence, meaning what do you have to think about when you are ready to buy your property?
So have you ever bought a land?
Yes, I did. It was an exciting process because, as an early investor, you are happy that you have a title on your hands with your name on it.
Right. So let's discuss about the first things that you do before you buy a property.
For those that are first time buyers, I would suggest to look into at least three things. Number one would be the fit for use, why you are really buying the property. The second one would be the cleanliness of the title. Is it clean? Is there any encumbrance? And the third one would be the issue on ownership.
So in short, this is you make your due diligence.
Correct. Very important in buying any property because it's really expensive to buy real property in the Philippines. How much is the zonal value already in BGC Taguig?
Yeah, it's very expensive.
Correct. And it's hard earned money for you. You've saved it for a lot of years. And after buying, you don't want to have a buyer's remorse, right?
That's true.
So, for example, let's discuss about the fitness for use. What is the reason you're buying the property? Is it for residential? Is it for commercial use? Or for any other purpose? For farming? For example, if you want to use it as a residential, is it really the right place for your family if you're staying there? Right? Is it a condominium? Is it going to be a lot where you can put up a building or your house? And you also need to see if there are issues in the ownership, meaning who is the seller? Are you talking to the real owner or is it just really a SPA?
An agent.
Or an agent, or you're talking about encumbrances. So, for example, recently we've been looking at a place to put up our second location.
Yeah, in Cebu.
Yes, and then we asked for a couple of documents like the copy of the title and the tax declaration. The property is really a good price. It's really nice. It's very near to the capital. However, there is a reason why we are having second thoughts in buying the lot. Mainly because when we saw the tax declaration, it says that it is residential. And we need that lot. The reason we're buying that lot is for us to be able to put up a building. So if it's a residential, there is some restriction with the city hall on how tall the building you can put up depending on the classification of residential. So that goes on the fit for use. If you will use it for commercial use, then you may want to consider looking at tax declaration. Does it state commercial or does it state residential or does it state agricultural even? Because there are restrictions on what you can put or what you can do with that lot if the classification is different.
Yeah, so due diligence is really very important before you buy a particular property.
Yeah, definitely. Especially if you would have issues on encroachment because you have to go to court before these are settled. If the neighbor is difficult, and aside from the money that you've paid to the seller, you still have to add or you still have to save up on other fees to clear up the issues of the title.
Okay, now after the due diligence, so what triggers the transfer of a title to another person?
There is a need to transfer the title if there is a change in ownership. So there are several instances wherein change ownership happens, like There is a simple sale, there is an assignment, there is a death, there is a donation, there is a foreclosure. So any of these events would require the transfer of the title from A to B.
So, what are the usual documents that you need in order for a particular property be transferred to another type person?
Okay. It is essential that you have the identification of the parties. So for the seller, you need his ID, you need his tax identification number. The same with the buyer, you will need his ID and tax identification number. Their specimen signatures would also be needed. If one of the parties is represented by an agent or attorney, in fact, you need a special power of attorney and the IDs of that special power of attorney.
What if the seller is a corporation?
Oh, yes, you will need a board resolution coming from the board and secretary certificate stating that the board is authorizing XYZ to sign the deed of sale.
Okay, great. Now you have the documentation. What do you do next? Where
There
do you go?
are three steps that you have to go through. The first one would be you go to the BIR to pay for the taxes. The second one would be you go to the city hall to pay for the city transfer tax. Then the third one would be the Registry of Deeds.
So, what are the fees associated with the transfer of the title?
Depending on the transaction. For this episode, we can discuss just the simple deed of donation or the sale. So, in these situations, there is a capital gains of 6%. There is a documentary stamp tax of 1.5%. There is more or less 0.5% that is being charged by the city hall or the municipality. And then there is also more or less 0.5% that is being charged for the transfer of the title at the Registry of Deeds. The taxes or the fees that you are looking at would be more or less the same if it's a donation.
Okay. So, who shoulders the capital gains of tax?
Good question. It is usually dependent on the agreement of the parties. The capital gains tax of 6% is usually shouldered by the seller, while the rest of the fees, notarial fees, the transfer tax with the city hall, the documentary stamp tax at 1.5%, the titling fees at the Registry of Deeds are all shouldered by the buyer. However, this is something that you need to be very careful of. The seller would want to have copies of all these payments because the tax code says that it is the imposition of the capital gains is on the property, so the seller would have to ensure that the capital gains tax is paid. In the same manner, the seller would want to ensure that the transfer taxes are paid before anything else because the BIR would want to go after you if the taxes are not paid.
So, what's the basis for the capital gains of tax?
It is based on the selling price or the zonal value, whichever is higher. So the zonal value can be seen at the website of the BIR. This is essentially a set amount per square meter that the BIR has set that the property is at this amount. Unfortunately, there are instances that they would want to underdeclare the
Yeah, or
value.
undervalue it. But we would advise for you guys not to do it.
Correct.
Just be honest with the purchase price and pay the government, right?
Correct.
Okay. How about in a scenario or situation where there are co-owners of a property? How do you usually deal with that? I mean, how does the co-owners transfer a title to another person?
It's actually better if, for example, you have co-owner A and co-owner B, right? Owning one land and you have that one title. It's better if the co-owner B would have to sell his rights or interest over that lot to co-owner A. But if co-owner A is unable to pay, then co-owner B now has the option to sell it to others. When that happens, the buyer would the usual process transfer of you in that situation it's a usual process of signing a deed of assignment or deed of sale, but the buyer would have to be okay that the interest will just be annotated on the title, meaning the buyer will not be able to get a new title on that property because it's still co-owned by or with it's still co-owned with uh, co-owner A.
Yeah, but you don't have a difficulty when both of the co-owners or all the co-owners would agree to sell it to the other
Correct.
buyer.
Yes, of course. Or if you have the chance to partition it, then what is owned by co-owner B, and then now co-owner C and co-owner A, if you can have a geodetic engineer surveyed it and then ask for partition, then that would be the ideal situation.
Okay. How about in a situation where the title of the property is registered under spouses? Do you need the consent of the other spouse if one is willing to have it transferred to another person?
Yes, that is a very good question because in our family code, there is a default that spouses are co owners of their properties. So you'll definitely need the consent of the spouse whenever you sell a property.
How about in a situation wherein the seller is in abroad? So what is the document or what are the documents that he needs to prepare or the buyer to ask the seller who is in abroad?
Right. If the seller, before leaving the Philippines, has issued a special power of attorney to an agent or an attorney, in fact, then that special power of attorney can be used to sell the property. But if the knowledge or the desire to sell the property already arose when the seller is already abroad, then that person would have to execute a special power of attorney abroad, but it has to go through consularization or apostille before it's going to be recognized in the Philippines.
How about in a situation where the Pasalo system?
Oh, yes,
Okay,
yes.
so when one of the buyer, say the property is mortgaged to a bank, but is unable to pay off his debt or amortization, and then he wants to just get out from that mortgage situation.
Yes, it's actually pretty common, especially those that are trying to flip their properties very fast to help the buyer finance the purchase. The buyer will just continue or assume the mortgage of the seller. Going back to our discussion on due diligence, this is a difficult situation because it's not really advisable because the pasalo system could have happened like twice or thrice or even four times, right? From the original buyer to the next one, to the next one, to the next one. It's going to be difficult. And also, if the bank would know about it, there is an acceleration clause because the bank really gave a loan or credit to the buyer. And when the bank made the due diligence, it's really the capacity to pay by the original buyer. So if you're going to do the pasalo, it's really a breach of the contract by the um, original buyer, now the seller of the property. But again, it happens. So there are documents that are being executed, like a deed of sale with assumption of mortgage. This happens when the buyer would assume the mortgage and would assume the payment of the mortgage on a month to month basis and would be the one responsible in remitting the loan or funding the bank where if it's an automatic debit funding the bank of the seller until the property has been sold has been until the loan has been fully paid. But if you are the buyer, it's really important for you to have special power of attorney and general power of attorney because if you are ready to sell the property, you will need the consent of the original buyer to sell the property because the title is under the seller's property. And then while the property is still on mortgage, you want to have general power of attorney to supervise, to lease, to use the property while the property is still under the name of the original seller or original, the one whose the loan is under the name of.
Okay, so after all the taxes has been paid with the government agencies that you have mentioned, how long does it take for the Registry of Deeds to issue the new owner's title to the buyer?
Yeah, generally you should be okay with 2 months. Sometimes it can be very fast, like 1 month, depending on the real estate agent, but it's okay also if it would reach 3 months. Sometimes it would reach like 6 months, mainly because if there are issues on the property. For example, you have encumbrances on the title. You would want to clean the encumbrances first on the original title that you have before having it canceled and transferred it to your name. For example, you have a mortgage, or the seller has a mortgage. You would want to complete or fully pay the mortgage first, and that mortgage be canceled on the title of the seller before having that title canceled and put it under your name. Because if you flip it, for example, transfer the name you transfer the title already under your name without completing the payment of the mortgage would be carried over to the new title. And then, while it's going to be clean because you're going to have it canceled anyway, there would be two liens already, annotation and then the removal of the annotation, which you don't want. Or also, for example, the sellers are the recipients of extrajudicial settlement of estate, right? There is a Rule 74 there. It is past 2 years from the time it was already annotated in the title. When you buy it, you want the Rule 74 to be first canceled at the level of the sellers before it's flipped, meaning before you have your own title. Otherwise, that Rule 74 will also be carried into your new title.
All right, that's tons of information there. Thank you, Attorney
You're
Mitch.
welcome. I hope you learned something. Bye.